Hello, everyone. This is Professor McKenzie. Today, we're going to be looking at Chapter 6, which is Criminal Law. The overall learning objectives, I want us to be able to understand how criminal law differs from civil law. We'll look at different various types and categories of crimes and define some of the more serious felonies. We'll talk about the question of criminal intent, as well as explain the basic criminal procedure and rights of criminal defendants. This is going to be our focus for Chapter 6. When we're looking at criminal law versus tort law, crimes are considered offensive against the state and against public good. And so any type of criminal code is going to, be designed to kind of regulate and try and manage problematic behavior in society. And so, the threat that we've created in our system, if you commit what's called a crime, if you're, if you commit it, if you're apprehended, if you're tried and convicted, then your sanction or your punishment could be jail time, could be criminal financial fines, criminal record, could be a prison sentence. There's a variety of different options at your disposal, depending on the type of offense that has been allegedly committed. Tort law is different, even though it kind of works well with criminal law. They kind of works hand in hand. We're trying to kind of encourage people to act in the best way and in the best interest of society. And so when we look at torts in the next chapter, what we're looking at essentially there is, instances where people have engaged in either intentional conduct, carelessness, or reckless conduct. That's sometimes called negligence, or if it's a strict liability situation where an injury has resulted. And tort law, which is part of civil law, normally the remedy there is some sort of compensation. Have you been injured? That's the kind of thing that we're looking at with tort law. Whereas criminal law, we're addressing, specific problematic behavior through the imposition of some kind of sanction or penalty. Tort law, what we're trying to do is we're not looking at any kind of jail or prison sentence, but we are looking at a financial penalty for the results of someone's conduct. So when we talk about the required elements in order to secure a conviction, there definitely has to be a mental state. So the person who's accused of a crime has to understand the nature of what they did was a crime. And that's going to be very situational specific. Obviously, if someone is, maybe in a compromised mental state, maybe through some sort of injury or through some sort of cognitive impairment, if they don't understand the nature of what they're doing, then they don't have the requisite mental state or intent in order to commit a crime. We still can deal with them. Maybe they have an insanity defense. And so there still can be, appropriate treatment for that person, but we're not going to send them to a jail or a prison environment. In addition to mental state, there has to be some kind of act. And so that can either be an act or a mission that is, actually carried out in order to commit the furtherance of whatever the criminal enterprise is. You don't have to have harm in order to secure a conviction, but that certainly does help the prosecutor's case when harm results. So think of, all the different types of crimes that exist. Let's say robbery, for example. Robbery is where you are approaching the victim in their presence in order to take something from them of value or property, and you're using the threat of violence, actual or constructive, in the furtherance of that robbery. So you have to satisfy those elements. You could certainly have attempted robbery. Maybe I'm walking out of a store late at night and someone approaches me in a parking lot and they have a weapon and they want my wallet. If I just give them my wallet and they run away, that's been a robbery. Assuming we can apprehend the person, we try and them in a court of law, and if they get convicted, they'll receive some kind of punishment. If before I hand over my wallet, let's say that a police officer just happens to be on patrol and the robber, the would-be robber, flees, and so my wallet wasn't taken. So obviously, there was an act there was an attempted robbery. There was certainly the mental states, assuming the person doesn't have, some kind of an insanity defense or some other mental impairment. But the harm that was sustained did not occur because I was not physically injured and they did not take any of my property. So harm, you don't have to have that as an element, but it certainly does help if you're the prosecution. That's kind of like, the icing on top of the cake, so to speak, in order to help secure a conviction. When we're thinking of, rights of the accused, so in our system, we have, in addition to the core U.S. Constitution that we talked about in a previous chapter, we also have the first 10 amendments that have been added to the U.S. Constitution, and those first 10 amendments are called the Bill of Rights. And contained within the Bill of Rights are specific amendments that have, protections that are hardwired for criminal defendants. So Fourth Amendment, that gives us the freedom from unreasonable searches and seizures. So Fourth Amendment is usually what triggers that is when law enforcement at any level, federal, state, local, when they conduct investigations and they're trying to gather evidence against a suspect. So, you cannot gain or acquire evidence through an unreasonable search. And if you do, then at trial, your attorney that represents the defendant can just simply ask that evidence be excluded. Depending on what it is, you might not get it back. Let's say you're being charged with drugs, drug possession or drug distribution. If law enforcement, if they, collect, let's say cocaine, you're not going to get that evidence back if it was, recovered in violation of your Fourth Amendment. But at least the jury will never know of that. And a lot of times that usually means the case just goes away if it's the key evidence against the suspect. Fifth Amendment, some of the criminal concerns there is, we're protected from what's called double jeopardy. So government has one chance to secure a conviction against a defendant for an alleged criminal act. And so if, someone is charged, they're tried, and at the end of the trial, the jury says not guilty, then for that alleged act, it's over at that point. The government cannot, rearrest someone and re-prosecute them for the same charge, for the same criminal act. They have one shot in order to do that. Likewise, every defendant is protected from self-incrimination. So we do not have to help the government convict us. So they can't force us to testify. In most criminal cases, criminal defendants are instructed by their legal counsel to not take the stand. And juries are always instructed by a judge to infer no guilt associated with that. That's just the defendant exercising their Fifth Amendment rights to not cooperate and not answer any questions for the charge or charges that have been filed against them. The Sixth Amendment, we do have a right to a speedy trial, which a lot of defendants waive that right. But, if you want to insist that the trial happen as quickly as possible, that is your right under the Sixth Amendment. And you also have the right to assistance of counsel, meaning that if you cannot afford an attorney will be provided to you. This was always a federal requirement, and it wasn't until the Supreme Court case of Gideon v. Wainwright, which was a Florida case. Now, for state charges, if someone is being charged with a state-based felony, then they're entitled to an attorney if they cannot afford one. The last element or amendment, I should say, that provides some protections for individuals and their individual rights when they're being charged with a crime is the Eighth Amendment. And so Eighth Amendment does a couple of different things. There are no excessive bail or fines that can be imposed. It has to be commensurate with whatever you're being charged with. And there is a ban on punishment that's deemed cruel and unusual. The best example to kind of illustrate cruel and unusual is the death penalty. The death penalty has greatly evolved since the 19th century. So if it was the 1800s, and let's say that someone was charged and convicted with, let's say murder. The death penalty back then was, either firing squad or maybe hanging. That was the two common methods used. Rope was pretty cheap, and bullets, weren't that expensive either. So that was the most common form of execution. We get to the 20th century, and with the advent of electricity, we wanted to get away from the brutality of public hangings and/or firing squads. When you hang a person, sometimes the head is severed from the body, and that creates, like a Quentin Tarantino movie, a very, very, graphic kind of like ending of someone's life. Same thing with the firing squad. If there were cases where people would be hit but not mortally, and so would you shoot them again? Would you let them linger? You could see the issues that surround the cruel and unusual aspect of it. So once electricity was kind of like developed and kind of it took off as part of our infrastructure, someone had the idea of, well, let's execute people through electrocuting them to death. And that actually existed for much of the 20th century, despite having problems with its implementation. Some people would actually catch fire, while being electrocuted. Some people would be electrocuted and then they wouldn't die. And so you would keep applying an electrical charge until they did die. So because of some of those anomalies that were occurring, what eventually kind of evolved by the end of the 20th century and now into the 21st century is lethal injection. And so lethal injection, I compare that to if any of you have ever euthanized a pet. The idea is that you inject someone with some chemicals and it slowly slows down their respiratory and cardiac systems until it ceases them, and then the person passes. And for years now, we've kind of thought, well, that's a foolproof way in which we can avoid Eighth Amendment issues of cruel and unusual punishment, and we can still execute individuals. The problem, though, is that there have been cases where, whether there's been a mistake in the formulation of the injection, prisons have been injecting, inmates that are on death row, and then they don't die. They just kind of have remained in this unconscious state. And the question is that cruel and unusual? There's been no definitive case law yet to kind of, determine, is this acceptable or not? Former Supreme Court Justice Antonin Scalia, who passed away in early 2016, he was a conservative jurist or justice on the court, and he was pro-life, pro-death penalty, which again we'll put the irony of that position aside, but he was definitely pro-death penalty as a Supreme Court justice. He felt that government had the right to kill its own people. And he acknowledged in his scholarly writings before he passed, he envisioned a court case at some point that's going to get to the Supreme Court where someone is being, sentenced to die. And their argument in their defense is that, a society or a government should not kill its own people. That in and of itself is cruel and unusual. And his position was that even though he's against this, he sees a day where the Supreme Court will just say that executions, even though these are people who have done very horrific things, let them sit in prison for the rest of their life, but it should not be the job of government to kill its own people. So, who knows if that's going to happen in 10 years, 50 years, that's the question mark. But that seems to be where the law is kind of headed, in that, if you look at the global community that embraces the death penalty, the United States is kind of in an odd club. China kills its own people, North Korea kills its own people, many Middle Eastern countries kill their own people, but most of the world, South America, Mexico, Canada, Europe, Africa, Australia, Japan, most countries of the world, they don't kill their own people anymore for crimes committed. So, who knows if, how long this trend will continue, but it does seem to be a likely result at some point that executions will be deemed cruel and unusual as a form of punishment in the United States. American support for the death penalty, obviously, it has fluctuated greatly in our nation's history. There still is, more people that are considered to be in favor of the death penalty as an option as compared to not. Each of you, I completely respect each of your individual positions. Sometimes students ask me how I feel on this issue, and I always, I try and think of this issue in the abstract and then in reality. And in abstract, I feel as a legal scholar that government should not be killing its own people. Obviously put people away forever, in a prison cell, that's fine, or an institution, whatever is most appropriate. But we as a society shouldn't be killing our own people. That's the abstract kind of academic in me. The pragmatist or the realist, in me, I personalize it, and I think of, well, what if there's someone that I love and care about, and let's say they're killed, they're murdered. I mean, the person who did it, I would be, I would want justice. I would want vengeance on that person because, of that, what happened, that emotional loss, that horrific event that occurred. And so that, I think, is where a lot of society kind of falls. It's like, maybe you think that there is an idealistic world that you would want to live in, but then you also understand there's reality, and so I get the duality of perspectives. I completely understand people that are pro death penalty, and I completely understand people that are con death penalty. Excuse me. Most of the executions that occur in the United States are based on violations of state law. And so you can see here in this map, the different colors of states, and you can see, according to the legend, the blue states there, they have no death penalty. So if you commit murder of one person or, multiple persons, the most severe punishment or sanction that you're going to get is life in prison. Purple states, they have the death penalty, but they have not performed any executions in over a decade. And then the gray states, they commit executions as needed. So again, you can see there is a definite split across a lot of the country in terms of, how is the country feeling when it comes to the topic of the death penalty. This is the map that I was alluding to, so for countries that still employ the death penalty, a lot of the countries on this list we're very critical of, when it comes to human rights violations. But again, we're still kind of tied, at least a majority of states, to this idea in the U.S. that death penalty should be an option for, first-degree murder anyway, or treason. Excuse me. One of the challenges with the criminal code in the United States, because we have a federal system, there is no uniform body of law state to state. There are similarities. If you commit robbery in Florida, punishment's going to be similar as if you compared, if you committed robbery in Georgia or Tennessee. If you commit murder, pardon me, please, in Florida, obviously, if it's first degree, the prosecution is probably going to seek the death penalty against you. But if you commit murder in Vermont, the most you're going to get is life in prison. So, again, there's no uniform state law per se that applies. So that kind of complicates things. Also the other kind of challenge when it comes to criminal law is that we can only charge people for existing violations of the law. If you do something new that we have not contemplated, then there may be no ability for us to secure some sort of punishment against a person. A great example is the case in the next slide involving Mean Girls in cyberspace. This case, if you've had a chance to read it, this case was from about 14 years ago, so like 2008. And this was pre, the cyberbullying legislation that's been enacted. In fact, all of those legislations were the result of this particular case. And so in this situation, you had an adult who pretended to be, a 16-year-old, a user of a boy online. And the purpose of assuming this false identity was to harass a teenage girl. And the goal being to kind of humiliate this girl. What the person did not realize what was going to happen was this girl felt so victimized by, the verbal and the text, kind of like bullying she was being subjected to that she actually committed suicide. And so, obviously this case gets a lot of attention, a lot of notoriety at the time because of what happened. And, again, there was no legislation that contemplated that someone would assume a fake identity and harass someone to the point of them committing suicide. And so, there were minor charges that were levied against the woman involved in this case. But at the end of the day, she, avoided, any kind of serious form of punishment or justice in light of the harm that she sustained and caused on the girl that eventually decided to take her own life. It's a lesson that, in the U.S., we have this idea of ex post facto. We can't retroactively punish people for something they did when there was no law against it. So this is an example where, that presents a challenge to that premise of our system of government here in the U.S. If we're looking at the burden of proof in like criminal versus tort cases or civil law cases, in a criminal case, guilt is established by, meeting every element of a crime, and the standard is guilt beyond a reasonable doubt. So that is not 100% certainty, but it is pretty close to that. So if you're the prosecution, you have to look at all the different elements of a crime, and you have to feel with some degree of certainty that you can establish, either at 100% or something pretty close to 100%, that there is no reasonable doubt that the jury members might have. If you're on a jury, part of the jury instructions, if it's a criminal case, is that if you do have a reasonable doubt, it is your duty to come back and find the person not guilty. Not guilty doesn't mean innocent. It just means that the state failed to meet its burden of guilt beyond a reasonable doubt in all of the elements required for that charge that's been levied against that person. If it's a civil case, normally in traditional civil cases, we're looking at what's called a preponderance of the evidence. Sometimes that's called the more likely than not standard, or the 50.1% rule. So the burden of proof is much lower in a civil case. So it's easier to win if you're the party that initiates a civil case as compared to being the prosecution that's the party that initiates a criminal case. When we look at the major types of categories of crimes in the U.S., we've kind of lumped them into three categories. We have, the most serious, we have less serious, and then we have, ones that are considered minor. That's very broadly kind of labeling those three categories. If we're looking at the most serious, those are considered felonies. And so the punishment for a felony conviction is at least a year in prison or longer. It could be for life, or it could be death penalty if you're in a state that has the death penalty. Misdemeanors are lesser offenses, and so these are crimes. You should not be doing them, but they're of such a lower offense level that the maximum punishment there is going to be up to a year in jail. You could involve also, maybe some kind of financial penalty. Below a misdemeanor are called infractions, and these are minor, very minor offenses. And usually the result is some kind of fine. And so you pay like a ticket. So like, let's say a speeding offense, or maybe careless driving, or texting while driving. Those would be considered infractions that, usually you just pay some kind of financial penalty. White collar crimes, these are cases involving either price fixing, maybe embezzlement or corporate theft, or maybe healthcare fraud or securities fraud. And so what distinguishes white-collar crime from traditional crime is that usually these are professionals who are using, maybe technology as a form of how they execute or carry out their criminal endeavor. So, think of like taking money from a bank. A traditional type situation would be like robbery, where it's like you go in brandishing weapons, you physically take money from the vault, or the till where tellers are, and then you leave, and that obviously, there's punishment associated with that. The other method would be maybe embezzlement, where you hack into the computer system and you electronically pull funds out of the bank and you transfer it to another financial institution. Both have the same effect. I mean, you're taking money that doesn't belong to you, but you're using different tools to kind of further that, criminal enterprise. Are you using a weapon, or are you using a keyboard? And the law struggles with this because usually white-collar crimes carry with it less punishment as compared to, crimes that are carried out in a violent manner. Even though the result is similar, in terms of, you're taking money that doesn't belong to you, it's, well, did you do something violent, or did you do something that, was very passive in terms of using, a computer, for example, to hack? The last slide in this chapter is Sarbanes-Oxley, and this is an example of a legislation that was in response to a corporate scandal at both Enron and WorldCom. These were two very powerful corporations, in their heyday, but eventually ended up going out of business because of embezzlement and accounting fraud. And so whenever there is, some kind of, big thing that happens, that's very bad on an industry, there usually is pressure by the public on lawmakers to pass legislation to maybe prevent this from happening in the future. And Sarbanes-Oxley, or sometimes it's, referred to as just SOX, is an example of that. So what SOX requires, if you're a publicly traded company, the federal government has a whistleblower hotline, so that if you know of criminal activity in your company, you can anonymously report it. Any type of document that's submitted as a publicly traded company, so like if you're the Securities and Exchange Commission, you regularly have to submit, quarterly and annual filings, balance sheets, income statements, and that's all part of your transparency as a publicly traded company. And so SOX now requires by the CEO and CFO that they certify those financial reports, that they're accurate and they don't contain any fraudulent information. So you either know that, your company is not engaging in fraud, or you were going to say that you should have known, so that puts a lot of responsibility on those two executives within the corporation. There's a ban on most personal loans. That was something that a lot of persons and a lot of investors didn't know that was happening at the time. That companies, in addition to stock options and salary packages, they would actually loan executives money and then forgive those loans if they met certain benchmarks, like hitting sales quotas or criteria. And so SOX put an end to that practice. And then overall, just enhance criminal and civil penalties when there are violations of securities laws. So anyway, hopefully you have a greater appreciation now for criminal law. If you have any questions, like normal, just let me know. I'd be happy to answer them. But have a wonderful rest of your day, and I'll be chatting with you all soon. Have a great day, everyone. Bye-bye.